As I mentioned, my name is Nisha Ajmani. I am a staff attorney at HERA. Thank you all for being here today. Today, I'm talking about legal rights of domestic to break their lease early. And I will answer questions at the end, but you're welcome to put them in the Q&A box as they come up. And so just in general, this presentation doesn't only apply to domestic violence survivors, it also applies to survivors of other types of crime involving violence, typically, or mental or physical injury. So I will get into that later, but just so you know, it doesn't have to be specifically domestic violence for it to potentially to apply to you. Okay, so the purpose of this presentation is to learn about your legal rights to end a lease early without penalty, without having to pay a late charge, for example. If a household member and or an immediate family member are a survivor of domestic violence, elder abuse, stalking, human trafficking, and or certain types of violent crime. So essentially, where it says immediate family member, it could be, for example, a parent who does not live in the household with you. So that would count, even though this person doesn't live in your apartment with you, for example. So why is early lease termination important? So the protections are in California Civil Code 1946.7. And these protections are important, probably, not surprisingly, because, it's crucial for survivors to be able to escape a dangerous situation. And this law allows survivors to escape that situation by limiting the financial repercussions that can happen when a survivor flees. So, for example, like I mentioned, a late fee or late back rent showing up on a survivor's credit report, which is harder to get credit, other types of debt, potentially debt collection lawsuit. So without these protections, breaking a lease early can have serious consequences for a survivor's financial health, credit score, and ability to find a new and safe place to live, especially if you need to list prior landlords when you apply for a new apartment. Obviously, if you break a lease early without this type of protection, most likely a prior landlord is not going to speak highly of that applicant. Of course, it always kind of depends on the context, but without these protections, it makes it a lot easier for landlords to speak negatively about a former tenant who broke the lease early. Okay, so I'm gonna talk a little bit more about Civil Code 1946.7. This is the main law in California that allows survivors to break their lease early without penalty. The survivor, or the tenant who is using this law to break their lease early has to give the landlord at least 14 days written notice of their intent to terminate the lease under this law, and must provide the landlord with documentation of the abuse or the violence. And so it's important here to note that the tenant who breaks their lease early under this law does not have to be the survivor of the domestic violence or crime. That person can be a tenant who has an immediate family member who is a victim of domestic violence or abuse, or a household member who is a survivor. So somebody who lives in the house with them, maybe a partner who is a survivor. Okay, so a little bit more about who this law applies to. This law applies not only to domestic violence situations, but also to survivors of these acts listed here. Um, Sexual assault, stalking, human trafficking, elder or dependent adult abuse, crimes causing bodily injury or death, crimes involving a gun or other deadly weapon or instrument, crimes involving the use of force against the victim or threat of use of force. And so you might be wondering, how is domestic violence defined? How do you know if you or a family member or a household member is a survivor of quote unquote domestic violence? So domestic violence is defined in California law in the California Domestic Violence Prevention Act, which is family code, starts at family code 6200, but specifically the sections 6203 and 6211 provide specific information that is helpful to understand what the definition of domestic violence is. So the law says domestic violence is abuse perpetrated against any of the following individuals. One, a spouse or former spouse. Two, a cohabitant or former cohabitant under Family Code 6209. Cohabitant is defined as a person who regularly resides in the household or a person who formerly regularly resided in the household. Three, a person who is or was dating or engaged to the abuser or is engaged to the abuser. An individual with whom the abuser has a child who is a subject of an action under the California Uniform Parentage Act. So essentially what this means is the perpetrator is attempting to establish parentage of a child. So that child has protection under this law. And then number 6, any other person related by consanguinity or affinity within the second degree. So essentially here, what that is, that from what I understand, that means it's like a fancy word of saying like certain types of relatives within 2 degrees, whether by blood or law. So this is important to note. Domestic violence and abuse is not limited to acts involving physical violence or abuse and injury. So that's a common misconception that only physical acts of violence qualify as domestic violence or abuse. So for example, domestic violence and abuse can also include emotional or verbal abuse or control, financial control, a violation of a pre-existing protective or restraining order, sexual assault, and stalking and harassment. That's not all. This is just a list of some examples. Okay, so specifically, what does domestic quote unquote violence and abuse mean? So the California, under California Family Code 6203, it says that abuse means 1, to intentionally or recklessly cause or attempt to cause bodily injury. 2, sexual assault. 3, to place a person in reasonable apprehension of imminent serious bodily injury to that person or to another. 4, to engage in any behavior that has been or could be enjoined pursuant to Family Code 6320. So that's another section of the Family Code that lists certain acts. So for example, harassment and stalking are listed in that section. And then also a term called quote unquote disturbing the peace, which I will talk about in a couple slides. And the statute specifically says abuse is not limited to the actual infliction of physical injury or assault. Okay, so what does disturbing the peace mean? So California law states that domestic violence includes acts of disturbing the peace. Generally, that term means a course of conduct that destroys the mental and emotional calm of a person. So these are, this is a case where that was defined, disturbing the peace was defined in SB 1141 is a law in California that was passed a couple of years ago and is in effect now, which I'll talk about later. So disturbing the peace can look like sending someone many unwanted text messages or making unwanted phone calls, sharing personal or private information about someone without their permission, or sharing pictures, for example, without their permission, trespassing on a person's property or appearing at a gathering uninvited. This is particularly relevant after the survivor has made it clear that they do not want to be contacted by the abuser in this situation. And violating a pre-existing protective or restraining order. So if somebody already has a temporary restraining order, for example, stating that the abuser cannot come within 100 feet of the person, and the abuser keeps on coming into within 100 feet of the person, that act of violating the restraining order counts as an act of abuse. And then, so what can financial abuse look like? It can look like not allowing you to work, withholding money from you, taking out credit in your name, running up large debt on joint credit card accounts without the survivor's permission, stealing money from you, threatening to cut off economic support unless the other person complies with the demands of the abuser, and controlling your finances. And you can find some more information about financial abuse and domestic violence at this website here. That's the California Department of Financial Protection and Innovation. So now I'm going to talk a little bit more about a term called coercive control, which is in the law that I mentioned a little bit ago, SB 1141. And so this law went into effect in California on January 1st, 2021, and states that domestic violence, the act of disturbing the peace, includes quote unquote coercive control. And coercive control is defined as a pattern of behavior that unreasonably interferes with a person's free will and personal liberty, and includes, among other things, unreasonably isolating a victim from friends, relatives, or other sources of support. And so I meant to emphasize this in a couple slides ago when I was talking about disturbing the peace. Most often what is the most helpful in just improving that disturbing the peace has occurred is if there's a what the phrase used in a couple slides ago was course of conduct. Here it's pattern, sorry, where did I go? A pattern of behavior. So typically what this means is there should be more than one incident. It does depend on, kind of the severity of the incident. So if somebody, shares private confidential information and photographs of you without your permission, that, in my opinion, would be, even though it's one incident, could be an example of disturbing the peace. But typically for harassment or stalking or anything of that nature, it's more helpful to be able to get a restraining order or a police report or something of that nature when you can show that this incident has happened more than once, and that you have made it clear you don't want that person to contact you. So that's it. It is important if somebody's contacting you and you don't want them to make it clear that you don't want them to in writing. So whether it's text messages or an email or something of that nature. Or you can also, block them and make a note that you've blocked them. Okay, so what does, oops, sorry. What can coercive control look like? It can look like isolating someone from family, friends, a support system, by not allowing them to leave the residence without the abuser's permission, or engage in or have phone calls with friends, or that sort of thing. It can also look like controlling what their survivor wears, where they go and when, what they can eat and when, if they can work, that sort of thing. Can also look like destroying the survivor's personal property, or forcing the survivor to pay for the abuser's rent or other items. There's a lot that can kind of go into this, the context of coercive control. So this definitely isn't a limited list. It's usually something that will be looked at kind of holistically, like what is a pattern, what are different things that the abuser has done to control the victim. Also, of course, verbal and emotional abuse counts here. And verbal and emotional abuse is a type of domestic violence. So there doesn't necessarily need to be coercive control for verbal abuse and emotional abuse to count, or to support someone getting a restraining order, though coercive control often coexists with those other types of abuse. Okay, so now I'll just get into more of the nitty-gritty about how to break your lease early under Civil Code 1946.7. So as I mentioned earlier, the tenant must inform the landlord in writing with at least 14 days notice of their intent to terminate their lease early under this law, and attach certain documentation. So the 14 days notice is the tenant would send that letter 14 days in advance of when they intend to vacate or end the lease. So even if the tenant moves out before the 14 days is up, the tenant is still responsible for 14 days of rent. So just keep that in mind. And if you've already paid rent for the month, for example, you're entitled to reimbursement of the amount of rent and the days that followed your 14-day termination. So whatever date that was, if it was, for example, May 14th is when your lease was terminated under this law, and you paid for the whole month of rent for May, you would be entitled to, there were 16 or 17 days, May 15th through May 31st of rent. And the tenant, when they give this notice, must also provide a form of documentation of the abuse in order to be eligible for this protection. And the tenant only needs to provide one of the following forms of documentation. I've listed them here. One, a police report showing the abuse occurred within the last 180 days. Two, a restraining or protective order showing the abuse occurred within the last 180 days. And this can include a temporary restraining order. So temporary restraining orders are usually about 3 weeks. There's also, in the criminal law context, there's like an emergency protective order, which I can't recall how long they last, but it's a protective order which the police give at the time an act of domestic violence happens. And so pretty much most types of restraining or protective orders you see would count under this law. A letter from a qualified third party, such as a domestic violence counselor, therapist, or doctor, confirming that the individual sought services for abuse or physical or mental injuries resulting from domestic violence or one of the crimes listed earlier in the statute. So that was, acts of violence involving a gun, making threats to an individual, that sort of nature. You can go back and look at that list later if you want to remember and have it saved in case it comes up for you. But and then so this third document, the letter written by the third party has to be within the practice of their employment and profession. So not a friend who happens to be a therapist writing a letter for you. It has to be a therapist who is working in their professional capacity as your therapist. And then any other form of documentation that, quote, reasonably verifies that the act or crime occurred. So this is helpful, if you don't have a police report or you don't have a restraining order, or don't have a letter from a qualified third party, which can also, of course, take some time, and maybe you don't have enough time to get that before you need to move out. So any other form of documentation, that can look like maybe an email from the abuser making threats to you. Of course, there's a date and timestamp on the email. It can be pictures of injuries, can be text messages. There's really kind of a lot that can be considered here. Personal notes, a declaration from the survivor. I mean, it really depends on the court and the judge to determine, what type of documentation counts here. But there's definitely a person shouldn't feel discouraged if they don't have one of the first three types of documentation. And definitely this is just a reminder to document, if something happens, if you or a family member are in a domestic violence situation, just make sure to document as much as possible, whether it is sending written communications to the abuser, taking pictures, telling, a close person that you trust, and keeping screenshots of text messages, anything that can prove that the other person was abusing you or threatening you in some way. So this is sample language that can go into a notice to terminate your lease early under Civil Code 1946.7. It really can be straightforward. You just want to put the date at the top, put your name, and where you live, the address of your rental, and then, just this basic straightforward language that follows the law. I or a member of my household or immediate family have been a victim of, and then you would insert one or more of these types of acts or crimes that this law applies to. Then you'd want to list the most recent dates of the incidents and kind of a brief summary about what happened. And if you know who the person was, if it's safe to write that person's name and description, you can do so, but it's not required that you do that. And then you would just want to make it clear, this is my 14 days notice to vacate under Civil Code section 1946.7. And then you would attach the form of documentation that you are including. So again, a police report or restraining order or a letter from a third party professional or any other form of documentation. Then you'd want to sign your name and put the date of your signature. And then it also would make sense to put the date of the end of your lease, that you're breaking early. So if you sign on May 1st and you give you send the letter to your landlord, you should say on the letter, the date of your letter, that my lease will end May 15th. So early under this law. Oops. And what happens after you, oh, sorry, just before I forget, it's also, if you're in a situation where you need to do this, this is a good template, but you can, if you have time, you can also try to contact a legal aid attorney to see if they're able to review the letter before you send it. Okay, so what happens after you break the lease early and vacate? So for example, what happens with your security deposit? So all the same laws that would apply in any, quote unquote, normal case of a tenant's lease ending would apply in this situation. So you're still entitled to your security deposit, and within 21 days after you vacate, the landlord must send the tenant either the full security deposit refund, or if the landlord is providing a partial refund or not providing a refund at all, the landlord must include a written statement explaining the deductions for damage beyond ordinary wear and tear and include receipts. So the landlord cannot deduct money from your security deposit for things in the rental that just kind of through the ordinary course of living and using the apartment would kind of get worn down over time. So carpeting, for example, if there isn't a big stain on the carpet that you caused, the landlord cannot deduct security deposit, installing new carpeting, for example. If there is a stain that you caused on the carpet, the landlord can deduct for cleaning up that stain. And the landlord can deduct for any services needed to or hiring and any professionals needed to make the apartment restored essentially to the cleanliness that it was when you first moved in. So it's important here, if you, I know that these situations are always difficult because people are in a very time sensitive timeline. And so to the extent you're able to try to clean as much as possible, or maybe get help from somebody or hire a cleaner to clean. And then so if the landlord does not have any valid deductions, they must send you the full refund. And you can find out more about this security deposit law at Civil Code section 1950.5. I think we have a training on security deposits on our YouTube page, I think. So it's definitely with our other resources out there if you want to learn more about security deposits. Okay, and then so when a survivor moves, especially in order to get your security deposit, you need to provide an address to your former landlord. So of course, there are situations where survivors are concerned about their confidentiality. So in this case, if you want to keep your address confidential, these are some things you can do. California has a Safe at Home program that allows survivors to obtain a PO box, a private PO box that helps maintain confidentiality. So you can find more about this program at this website, and call this number for more information. You can also request a court order prohibiting the abuser from taking any steps to learn your new address. And you would want to list an address of a trusted family member or a friend, or you can write on the court paperwork that your address is confidential per family code 6203. And then you can also, for when you give information to your former landlord, you can provide the address of a trusted family friend or family member or friend to receive the security deposit refund, or someone else who you trust. Okay, so that's everything that I wanted to talk about related to ending your lease early. This is some general information about HERA's services and how you can contact us. So we help people with debt collection issues, including student loans, auto loans, medical debt, credit card debt, different types of homeowner loans. And then credit reporting, so people who have been victims of identity theft, that also comes up in domestic violence too, especially if the abuser, uses your identity to apply for credit, and then you have debt in your name for credit you did not take out and without your permission. We help folks review their credit and determine, what they can do to improve their credit. Other types of financial products and recommendations, mortgages, so homeowner protections and foreclosure prevention. Then the tenants team, which is the team I'm on, we help with any pre-eviction concerns, including landlord harassment, fair housing, habitability, and debt concerns when seeking housing, as well as just, kind of anything that comes up before an eviction. So it just kind of runs the gamut there. But if you've been served with an eviction summons and complaint, we're not able to represent tenants in eviction defense cases. So we give referrals out to folks in that situation. But if you've been served with a notice to vacate and not a summons and complaint yet, we can help to try to prevent that summons and complaint from being served. And if you want more time to move out, or you dispute what the landlord is claiming as a reason to vacate, then we can help try to get you more time or determine whether the landlord actually has the legal right to serve you with a notice of termination. We also help out veterans and service members with different issues. And then we have an estate planning team. So all of our services are free, but I believe the estate planning team has like a sliding scale. I could be wrong. Alejandra is on the call. She might know more, but I'm pretty sure it's, okay.
Yeah, so I'll note here for estate planning work, all of our services are statewide. I know we have a question that came in just now. If our services are statewide, they are. We serve the entire state of California, only California. They are free of cost for all services except for estate planning. Estate planning, it's, to create a will or trust to protect your home. The fee to create that, it's on a pay scale, so it depends on your income. So sometimes if you're a lower income, sometimes there will be, it'll be free, or sometimes it'll just be a small fee. So it just depends. So that's something that we would be able to determine and help you with here at HERA. And our services are for anybody, and it just not anybody who is just a domestic violence survivor. It's just for anybody who's going through any of these different things.
Yeah, thanks, Alejandra. So it does look like we have a couple questions. So I want to get to those. The first is, would elder abuse include exploitation or fraud, such as victims of transnational scams? So here, are you meaning like a scam from another country? They call you and say that the alderperson owes a certain amount of money. I think that's what this person means, but correct me if I'm wrong. So typically elder abuse means, in some way like monetary value is taken from a senior or defrauded in some way. The thing with these international scams is I'm not sure how they are held accountable because it's international. I don't know international law, but there are definitely laws against that. I do know that. And to the extent that there's any kind of office in America that handles or that does these scams, that could be relevant. But if it's just international, yeah, I'm not sure how that would like how the scammer would be held accountable. But it could, I think there's still an argument here that to the extent the elder needs to escape, maybe the scammer knows their address. I think it's definitely it would be relevant to try to argue that this law applies to them. Okay, and another question is the reason for the statute only due to safety issues staying in that location, or can it also be because a victim can no longer afford to live there due to exploitation or fraud? Dungeon. Yeah, I think that can also be a reason to be able to use this statute. So typically, I mean, well, technically, one can argue that exploitation and fraud is a form of financial abuse. And so there isn't any requirement in the law or stating in the letter that says that the person doesn't feel safe. There's no requirement that has to happen. So as long as there are incidents that this person can reference in terms of financial exploitation and fraud, I think that's enough to just list in the letter providing notice. Our service is statewide. Yeah, I already answered that. No, we're not DV only. We help anybody. Who would we have to contact? You as a presenter for, sorry, what, I'm not sure what MDT group is. Can this person put that explanation in the question box?
Yeah, I would say whoever asked that question, if you want to send an email over to our inquiry email, I think it's listed. Is it listed on the
It's
slide?
not. Maybe we can put that.
And that's okay. I'll
Okay.
respond. Yeah, I'll respond to this question and I'll share with you our email, and you can send us an email there to further, discuss this. And just for those listening in, our main general email is inquiries@HERA ca.org. That's inquiries@HERACA.org. Or you can also always give us a call. And the email is also on our website, which is listed on this slide. It's at www.heraca.org.
And if you haven't already, definitely put your email address in the Q&A if you want copies of the slides, and we'll get that to you as soon as possible. I still have time to answer questions, so if there are any other questions, happy to answer them. Oh, this person clarified, just to present at a group, there are multidisciplinary teams dealing with these issues. Yeah, I mean, I think that probably makes sense. I think that's probably something we could do, but definitely email the inquiries just so we can learn more about what this type of presentation and group is and what you're seeking. Okay. Ollie, and you're getting the people who are listening there, right? Okay.
Yes. So thank you to everybody who's sending in their emails through the Q&A. I will be sending over the PowerPoint slides sometime today. And along this video, along with a few of our other domestic violence survivor series videos that we have hosted here at HERA, they should be posted or will be posted on our HERA YouTube channel. Again, I would say go on our website and you would find more information there about who we are and what else we do. And then if you scroll all the way to the bottom, there is a YouTube button, and it'll take you to our YouTube channel. Or you can go on YouTube and type in HERA Housing and Economic Rights Advocates, and we should pop up there. Okay.
Okay, well, if there are no other questions, thank you, everyone. And yeah, definitely stay in touch and check out our website if you want to learn more. Okay.